G'day. Again, thanks for listening. Today I want to talk about Australian consumer law. The problems with this Australian consumer law is it's used in many ways. One of the worst ways it is used is the fact that builders and home inspectors will suffer the wrath of Australian consumer law if it's not utilised correctly. It creates an unrealistic expectation for the consumer to come up with a reason to say that your work is defective, whether you're a builder or a home inspector. Yet, in Victoria, the Supreme Court has deemed Australian consumer law under a federal act and not a state act. So if you go to NCAT, VCAT or QCAT, it can't be used. Make sure that your legal representation are aware of this. There are plenty of cases on the Victorian Supreme Court website that allows you to go to Australian Consumer Law, NCAT or VCAT rather, and that way that you will be able to download and print off the regulation under that Supreme Court finding. Many people under consumer law have an expectation, and this expectation comes from conversation, not what's written. So make sure that what is written in your specification or your quotation, even what you say, which is hearsay, at the day of the quotation, if you're going to make notes about what you say and what they say. If you don't have those notes, therefore, the acknowledgement clause at the end of contract law will not work. There has to be approval. There has to be an acknowledgement in every damn case. So make sure that your contract and your quotation is acknowledged as being true and correct as to what the client wants before they sign it. And once it's signed, Australian consumer law will have no play whatsoever in your contract documentation. See you later.